Okay, well, we'll get started. Good afternoon. My name is Joel Reidenberg. I am a visiting professor here at Princeton at the Center for Information Technology Policy, and I'll be moderating our session this afternoon with our panel of judges looking at judging technologies and some of the difficulties and problems and issues judges face when they're confronted with new technologies. And we have a fantastic lineup this afternoon. I'll introduce them in the order that they're seated and tell you a little bit about them. To my immediate left is Jean-Jacques Gomez, who is a retired judge from the French Cour de Cassation, which is the Supreme Court of France. Prior to serving on the Cour de Cassation, he was a judge in the Paris Regional Trial, the trial court for Paris, which is the most important trial court in the French legal system. He grew up, he has a very interesting story. He was born in Algeria and grew up in a very small village in France, in Alsace. As he once described it, at the bottom of the bottom of the social heap in France, and went to university in Strasbourg, was first in the class for the graduate school for judges. In France, the judiciary is a civil service function, and became known as the internet judge in France. He had many famous cases. Almost every internet case in France went through Judge Gomez, his court, and his pen for the decisions. And the Wall Street Journal, it's quite uncommon for the Wall Street Journal to talk about a French judge, but they did a profile on Judge Gomez a number of years ago, and I don't know any other judge who's had the opportunity to order both Vince Cerf and Princess Caroline of Monaco to come into his chambers to talk to him. So we have Judge Gomez, who I should say also, one of the wonderful things about the panel today is he ruled on the Yahoo case in France. It's a very famous case more than a decade ago involving the display of Nazi memorabilia on a website that was an eBay-type website. And Judge Gomez ordered them to filter and to block access to French users. Sitting immediately to his left, who he's never met before, is Judge Jeremy Fogel from the Northern District of California. He's a trial judge in California. Judge Fogel decided the Yahoo case in the United States. So they were dueling opinions. It was a transatlantic controversy that we'll have an opportunity to talk a little bit about that. Judge Fogel started out his career. He is a graduate of Stanford and Harvard Law School. Started out his career as a judge, as a trial judge in the state courts in California, and was appointed to the federal bench by, I want to say it was President Clinton? Mm-hmm. President Clinton, to the Northern District of California, which has all of the prominent West Coast technology cases. So cases you've probably, aside from the Yahoo case, Lentz versus Universal Music was one of his famous cases. Remember there was a YouTube video of a kid dancing on the internet, and there was it was Prince's song, Let's Go Crazy, playing in the background. Well, Universal Music sent a takedown notice. And that case, very famous case, wound up before Judge Fogel. The Diebold case, when they sent threatening letters to students, was another one of his famous cases. So he's had just a tremendous impact on the technology cases of our epoch, our era. And he's currently serving as the director of the Federal Judicial Center, which is the training center for federal judges in the United States, newly appointed judges and continuing education of federal judges. And to his left is Judge Denny Chin, who I think is probably no stranger to many in this audience, and certainly no stranger to Princeton. He's a graduate of Princeton, member of the Board of Trustees here at the university. He had the good fortune to go to Fordham Law School, where I teach now in my normal time, and has been serving, he served first on the bench in the Southern District of New York, was appointed by President Clinton, was the first Asian American federal judge outside of California, the Ninth Circuit in California, the first one to be appointed outside of that region in the country. He joined the Second Circuit Court of Appeals almost 4 years ago to the day, actually. Later this month is the...
April 10th, yes.
Oh, wow, okay, I thought it was a little late, April 10th, wow. It was appointed to the Second Circuit by President Obama. And if I remember correctly, you were confirmed unanimously?
98-0.
That's unanimous. No one opposed it, which in this day and age is extraordinary.
Well, one of the senators who was absent had been on the Judiciary Committee and had voted yes. The other senator who was absent sent word that had he been there, he would have voted yes. So we can call it unanimous.
Yes. Unanimous, which is just a remarkable testament to how highly well respected he is for his tremendous work. And Judge Chin has seen cases that you're, I'm sure, familiar with. The Google Books case was one of his trials. The Aereo case that's being argued before the Supreme Court in a couple of weeks.
April 22nd.
April 20 had a very interesting dissent, shall we say, in that decision. So again, many of the East Coast technology cases found their way to Judge Chin's court. So we have a really extraordinary panel of expert judges. I've asked them to start out by just giving a few minutes, 5 minutes or so, 10 minutes of reflections on just some of the things, perspective as a judge dealing with these cases. And then we're going to do it as sort of a fireside chat, talking more about some of the things they've dealt with, common issues they've had. Maybe we'll talk a little bit about some of the challenges with the Yahoo case in particular. And then questions from those of you in the room. At the conclusion of the panel, we're going to have a little reception afterwards, so I hope you'll all join us for that. So with that, I'm going to turn the floor over to Judge Gomez to start us off.
Thank you. I must apologize. I don't speak very well English, and I don't understand always what in English is being said to me. So I need the help of Joel Reidenberg and you all along this audience. Beginning in the years 1995 and forward, judges had to face many questions about the functioning of the internet and also the tools for its use. Judges had to invest in the understanding of the technological tools and the impact on different areas of law. Quickly enough, they had to provide legal answers and decisions on the internet's application to people's lives as technology evolved quickly and as the business world rapidly adopted the technology. Eventually, judges learned how to master the technologies which allowed them to render decisions and opinions in legal domains as diverse as intellectual property, privacy, copyright, domain name issues, unfair competition, frauds of all kinds, breaches and attempts against our common democratic principles. Nevertheless, most judges were of the opinion that it was not necessary to rethink the law, but rather to adapt the rule of law to the actual technological reality. What is true of the internet is also true with drugs, in the sense of medications. We all know that drugs designed to fight certain diseases have sometimes proved dangerous for some individuals, or on the contrary, sometimes proved beneficial in fighting other diseases which were outside the scope of the drug's initial properties. On the internet, hackers, as well as all those who understood the usefulness of the network for criminal or anti-competitive activities, were able to use their technical knowledge combined with a desire to circumvent the basic precepts and principles that rule the society for purposes greatly varying from the internet's original purposes. Stealing content, stealing data, controlling remotely distant computers, disseminating gossips, slander and lies, harming other people's reputation, breaking into security systems, setting up pedophile and prostitution networks, forging diplomas or pay slips. Judges had to render specific decisions for all of these reprehensible behaviors. Sometimes, so the speed of the judicial response could appear too long for many in society. If I predict that other uncivil and delinquent behaviors connected to the development of new technology will continue to occur, I hope that I will not be seen as a bearer of ill tidings. Our discussion today is really about how we as judges meet these challenges without overstepping our role and endangering democracy.
Okay, thank you. Judge Fogler, you
So, first of all, I just want to say what an honor it is to be here with my two colleagues. I've followed both of their careers, actually, ever since Judge Gomez and I had that case together, and they're both great judges, and it's a pleasure to be here with them and with you. The thought I had about just a good starting point is when you think about communication, and go back to the founding of our country in 1789, that communication was face-to-face. It's the only kind of communication that there was. Mm-hmm. And so you have a legal system which was built around people being in the same physical space, talking to each other, looking at each other, and a whole set of legal relationships growing out of that. The whole notion of jurisdiction, contracts, torts, all of the different areas of the law assume that people were going to be in physical contact with each other. And the other thing about communication is at that time it took a very long time, unless you were right in the same place. Like if Judge Gomez and I had cases, and he's in Paris and I'm in San Jose, it would take probably about 5 or 6 months for our communications to get back and forth, if they got there at all. So the whole pace of communication was so much slower. And over the last 230 or 40 odd years, it's evolved into something completely unrecognizable to the people who wrote our Constitution and who wrote our original laws. Now you can communicate instantly about anything with anyone, and you really don't even have any idea who that person is. It can be an avatar. It can be a false identity, and we have all of these legal relationships that occur in cyberspace, and it's just raised so many issues, so many problems that we don't have a framework for. We try. We have courts that try to deal with it, and we have legislatures that try to deal with it, but they're always behind the curve by a long way, and we don't really have answers. So when you have a situation where, let's say, the content of a communication is a capital offense in one country and is protected by the Constitution in another country, and that's happened. What do you do about it? And so what I find so challenging about this area, and all of the cases that I've had being in a venue where most of the internet companies in the U.S. are located, is that we can't make it up. We have to draw upon the common law. We have to draw upon the statutory law that exists. But it is really hard to figure out what to do, and that's what makes the cases so hard. And I think it's a very unusual place for judges to be. When you think about judging, judges are supposed to apply the law. They're supposed to go to the law book and look in the law book and figure out what the law is, and then apply it to the facts of the case. Judges aren't supposed to make things up, and yet we face situations in this particular area where we really are writing on a clean slate, and we have to figure out what are the principles that are going to guide us. And I've found that to be incredibly challenging. I'll just leave it there. I mean, we'll talk more about specifics.
Well, thank you. I'm also delighted to be here. Last Thursday night, I was here at Princeton talking about lewd Chinese women. Some of you were in the audience. A case involving immigration and human rights and federalism. And here I am today to talk about technology and judging. When I think of judging and technology, I think of it in three areas. First is substantive issues. Second are practice issues. And third is what I would call internal issues, internal judging issues. So just a few words about each area. In terms of substantive issues, the challenge is for us as judges to try to keep up with the pace of technology as we continue to have these changes. Trying to adapt traditional legal concepts to technology as things are changing every day. You know, we've gone from the Sony Betamax to the DVR to streaming and the cloud, and yet it's the same Copyright Act. And how do we apply the Copyright Act to these changes, and things are different. In some of the areas particular areas of the law where there have been challenges is copyright. Google Books is about fair use. The copyright laws have been with us for many, many years, and the doctrine of fair use has been with us for a long time. But back then, there was no internet, and what's fair today might be a little bit different from what was fair 200 years ago. Another area is the Fourth Amendment, the criminal law. There are many issues raised because of evolving concepts of reasonableness. The Fourth Amendment is about what's reasonable. Well, is putting a GPS device on someone's car a search within the meaning of the Fourth Amendment? Other cases there are a lot of cell phone cases now. What can the police do with respect to your cell phone? Bringing your laptop in at the border. And you know, there are liberal rules regarding search at borders, but now you have your entire life on your laptop. Is it reasonable for the government to want to take that and search the whole thing? You know, the internet has made it easier in some ways for criminals to commit crimes. Child pornography has exploded because of the internet. At the same time, law enforcement has come up with many new techniques to try and deal with it, again, because of the technology. We had a conference at Fordham a few weeks ago about the Internet of Things. I had never even heard of the phrase until I prepared for that conference, but these days so many things are connected by the internet. Monitoring devices, so that if you have a house in the country, there's a device on it that will monitor the temperature, and if it drops below a certain temperature, it'll automatically turn up the heat. We heard of one where your alarm clock is connected to the internet, and then if they detect a car accident on your way to work, it'll send a message to your alarm clock, and your alarm clock will wake you up 15 minutes earlier so that you can deal with the traffic. But these types of things also will raise complications in terms of the law, as they will generate many legal issues. And of course, privacy, security have all been complicated by the internet and jurisdiction, as we saw in Yahoo. The second area, practice issues. There are a lot more issues now raised, again, by technology. E-discovery. Discovery is more complicated now because so much of it is electronic. How do you preserve it? How do you find it? Who pays for it? So much more information is available. The management of juries. If I'm charging a jury, I've got to be careful to instruct my jurors. No blogging. No, don't Facebook your fellow jurors. That has happened. You know, be careful what you post You can't post, you can't blog about what's going on in your trial. So these are things that we now have to deal with. And from the lawyer's perspective, there's a lot more information out there now about prospective jurors. Presenting evidence. It's very common at trials now to have PowerPoints, very fancy PowerPoints and other devices to help present the information. I haven't seen many e-briefs. Once I had a really big case and there were e-briefs, so the brief was submitted electronically and citations, there were links to the cases. That's the easy part. But if they cited a deposition transcript, there would be a link and I could see an excerpt of a video of the deposition. There just haven't been much of it, but again, that's a possibility. And then finally, just a couple of words on internal judging issues. Many judges are not tech savvy, and many judges are not familiar with things like social media. I do not do Facebook. I think most judges do not do Facebook. We don't do LinkedIn or any of those things. So if you're a lawyer bringing a case, it may be that the judge isn't familiar. In the Second Circuit, we are still communicating with each other by fax. We're still using fax machines to send our comments back and forth. On the other hand, we do have law clerks right out of law school who are familiar with these things. But it's the nature of our jobs that we will learn something. So if I get a Facebook case, and even though I don't know anything about Facebook, I can learn it, and it's up to the lawyers to teach me.
And can I just pick up on that?
I'm done. So
No, because now I teach judges, so I actually see things that I didn't used to see. It's changing. That judges our age, I think what Judge Chen just said is correct, that most of them are not technologically savvy and don't use social media and don't. Anybody under like 45, 40, I mean, they do. And in fact, it's very hard for people who have come out of law practice who are that age to give up Facebook. They don't want to, and there's some ethical reasons why I don't think judges should be on Facebook, and we actually teach that. But people are really comfortable with it. I was at a meeting. It was a conference of one of the circuits we were out in Colorado, and the judges were standing around on the deck with their iPads, working on a case. They had access to the briefs, the docket, the arguments, their notes. It was an appellate panel, and they were working on their opinion on a deck in Estes Park on their iPads. So I think this is it's a generational change, and it's coming.
Yeah, it's changing for sure.
Yeah.
We only got iPads in the Second Circuit about 2 years
yeah.
ago, and we're still lugging around
Right.
piles and
Yeah.
piles of these heavy
Yeah.
briefs.
But then, how do you deal with cases where the technologies that are coming before you, even if younger judges today may be more attuned to today's social media, but the likelihood is they're going to be facing cases that are technologies that are light years ahead of that, just as each of you have. I mean, how do you deal with the case where Google book scanning, have you ever seen anything like that? Or when, Judge Fogel, when you had to deal with Yahoo, and Judge Gomez, when you dealt with Yahoo, I mean, these were technologies that you probably had not encountered before.
Well, Yahoo was actually, the jurisdictional part and the content of the case were not easy at all. They were actually quite challenging.
We should probably pause 1 second to explain, because I don't know that the whole audience knows. The Yahoo case starts in France, where a student group brought a lawsuit before Judge Gomez seeking what we would call an injunction against Yahoo to require Yahoo to block access to its auction website, to block access to the Nazi memorabilia offered on the auction website. And Judge Gomez orders Yahoo to block access. Yahoo then goes to Judge Fogel and seeks a declaratory judgment that the French decision could not be enforced in the United States, that it violated the First Amendment in the United States. So that's the context.
And Yahoo had a Yahoo France, which Judge Gomez clearly got jurisdiction over. but there was also Yahoo.com, which was based in my
Yes.
neighborhood.
In
So,
California.
so that's how that happened. And I know we want to talk about that, but just this last point about the technology, that was pretty easy technology, actually. There were other problems with that case that made it very, very challenging. But we get technologies that are, there's a reason why we all became judges, right? I mean, not computer scientists or engineers or, organic chemists or whatever. I mean, there's stuff that it's just, I remember that, and, just to get very personal about it, I had a case once that was a patent case involving the logic in a particular kind of computer chip. And I had about a 2-day hearing trying to figure out what the invention was. And after 2 days, I still didn't understand it. And I had one of the worst migraines I ever had in my entire life. I mean, this stuff is actually really, really hard, and we're not trained to do it. I think somebody could do a doctoral thesis here at Princeton on what the invention was in that particular case. But, that's why they're getting a doctoral thesis, and that's why I'm a judge. It's like so one of the problems we have is figuring out how we can understand enough of the science that we can make a decision that isn't just completely arbitrary. And I think that's a problem we are increasingly facing because the technology is getting more and more complex.
When you faced Yahoo for the first time, though, you were faced with various technical arguments made by Yahoo. And what did you do?
What I did? Perhaps can I answer in French and you could help me
Okay.
translate? Yes, because I can, but I don't. I am surely not in the position of saying everything in English. Yes, when I was faced with Yahoo case, I had a great problem of comprehension of the technology, of the internet technology. And I had the chance in France to be accompanied by persons we name experts who
You as the judge can choose an expert.
But I was also the responsible of a department of the experts in the Court of Appeal of Paris. Yes, and that j'explique en français peut-être c'est plus simple. J'étais responsable de tous les experts de la Cour d'appel de Paris.
He said, I was the head, in charge of all of the experts who could be appointed by the Paris Appellate Court. So the court has an accredited list of experts,
Yes, yes.
and that was under Judge Gomez's responsibility at the time.
We had 2,300 experts in all the dans toutes les disciplines.
In all different fields. They had
Fields,
accredited
yes,
experts across all different fields.
Et en particulier, s'agissant d'Internet et de l'informatique, j'avais beaucoup d'experts autour de moi.
And with respect to computer science and in particular the internet, he had a very long list actually of experts who were accredited at the time. This was 2000 actually.
Yes,
2000.
yes. Et donc, j'organisais dans mon bureau des réunions avec ces experts et je leur demandais pas de me donner la solution, mais de m'expliquer le fonctionnement de la technique en quelque sorte.
So what he did was he asked a group of these experts to come to his office. We would call that in chambers. To come in chambers and explain to him how this worked. Give him a lesson. Essentially,
Yes,
tell
yes.
him how this stuff
That's
works.
right, yes. Et donc, je comprenais, mais après la décision, c'était moi qui la prenais tout seul. Mais je ne voulais pas dire dans une décision quelque chose qui n'était pas vérifié par la technique.
So what he did was he took what they told him, and then it was up to him to make a decision as to how he was going to proceed. But he said he wanted to make sure that there was nothing in his decision that was going to be technically wrong, that he had the technology right in this decision.
Were these
Yes.
experts that Judge Gomez picked, or did the
No,
parties provide
no.
them?
They were not paid. at
No,
all.
were they picked by
Who
you?
chose them? Who chose them? Qui a
them?
choisi
Yeah.
les experts?
Non, mais attendez, il y a deux temps. Il y a les experts dans l'affaire
Right.
Mais il y a aussi les experts qui étaient mes conseils.
He had
Yeah.
two groups of experts.
Yes.
He had this group he was talking about were the experts who he brought in just to be
Yes.
his private advisors.
Yes,
And then there was
exactly.
a second group of experts that were experts in the case itself.
Yes, yes.
So he's talking initially, he went to the list of accredited experts, invited, il y avait combien que tu invitais là-dedans?
Oh, moi, parfois 8, 10.
So he would invite them in groups of 8 or 10, small groups, to come and instruct him on the technologies,
Yeah.
so that he could get up to speed.
Yes.
Okay.
Et après, dans l'affaire Yahoo, j'ai désigné des experts, et donc, mais j'ai voulu prendre des experts du droit français et du common law.
Okay, so for the case itself, he chose the experts. And in making the choice, he wanted experts both in French law and from the common law side. He wanted on both sides,
Yes.
both perspectives.
Yes, and American law. And so I chose Winton Cerf,
Then Cerf was one of the experts he
for
chose.
an American expert. Ben Laurie, he was an English,
Ben
English
Laurie, yeah.
expert, and a French expert. I had to be accompanied by a French expert. And I asked them a few questions. I asked them, is it possible to block,
To filter.
right? to filter the French users, not the other users, but the French users from le site américain.
From the American, from the Yahoo auction website.
Auction website, yes. And j'ai attendu leur réponse. Ils sont venus exprimer leur réponse en public.
So he waited to get, he got their answer, which was a written answer.
Yeah, written.
And then he had them appear in public session in court, in open court session.
Yes. Alors, juste une parenthèse, c'est la première fois que j'avais mis en place une expertise par ordinateur entre 3 experts étrangers.
As a little parenthesis, it was the first time he had expert witnesses appear by computer en trois lieux différents.
Il y avait l'Amérique pour Winton Cerf, il y avait
By
l'Angleterre.
video conference.
Yeah.
They had the 3 showing up by video conference in the court in France in 2000.
Voilà, donc ça c'est la parenthèse. Et donc ils ont échangé et après ils se sont rencontrés pour faire le rapport.
So then after appearing in court, they then the experts got back together again for the final version of their expert
Yes.
report.
Et après ils sont venus devant la cour donc pour exposer leur point de vue.
And then they came back to the court to formally present their opinions on the questions that Judge Gomez had posed on the technologies.
Et alors ce qui est différent entre le système américain et le système français, c'est que dans le système américain, ce sont les parties qui apportent leurs experts. Dans le système français, c'est le juge qui nomme un expert.
Saying the difference between the U.S. and the French case is in France, the judge chooses the expert, whereas in the United States, it's parties choose.
Well, it's this is one of the fundamental differences between the civil law system, which is the system in France, and the common law system, which is the system in the U.S. Ours is an adversarial system, so the judge, it's not entirely true, but the judge basically is supposed to be a neutral umpire, and the parties are the ones who present the evidence and develop the facts. And if it doesn't get developed and the judge doesn't hear it, well, then it just doesn't get heard. And in the French system, and in most of Europe, actually, the judge is more of an investigator. The judge's role is to develop the record and ask these kinds of questions and to find the right experts. And so it's a very different theory of what the relationship between the judge and the parties is.
And even in the civil cases.
Right.
Yes,
That's right.
in criminal cases, this
Yeah.
is right, but even in civil cases. And then when the experts, yes, another point, the judge has no obligation to accept the conclusion of the experts. The judge is not, cannot say, I'm better than the expert. No, he's not able to say that, but he can say yes. The conclusions of the expert are not so precise.
So precise.
So precise. Yes.
On point, we would probably
Yes,
say.
and then he can give his own decision over the report of the expert. But in the case Yahoo, the three experts, then Winton Cerf, he was a great expert in America. Ben Lowry, a great in England, and Vallon, he was a great expert in France, said it was possible to filter until, I think, 90% the French users to visit the Yahoo.
.com.
Yes, and then I said 90%. This is a very good number, a good percentage. Yes, but they said no. You cannot say it was a good percentage because a good percentage is 100%. Yeah, I said then we shall add three or five questions more, and perhaps can we obtain a better result. And we asked a few questions. Are you coming from France, or do you use French navigator of sorts? And we arrived to the percentage of 95, 96. I said it's a very good percentage, because in the common life, when you obtain such a percentage, is it not a good percentage? Other way I didn't understand. And so I took the decision to order to Yahoo to filter the French users, only French users. Yes, after my audience, my session, of course, yeah, Winton Cerf said, yes, I said it was possible, but I didn't accept the principle of filter the internet users.
He wasn't happy with your decision.
Yes, he had a great problem because he was in America, the man of the liberty of internet, and he had to say, yes, I have said in France it is possible to 80%, but I don't want at all that we filter the users. Yes, this was his opinion, but personal opinion, but not a technical opinion.
Right.
And I was only
You needed the technical.
technical opinion. Yes.
The two of you have also faced these kinds of problems. What you have to do is quite different from what Judge Gomez is able to do. Danny,
Well,
do you want?
Yeah, sure. I mean, there are some differences between our system. One is, in our system, the judges hear all kinds of cases. I mean, we hear criminal cases, we hear commercial cases. In many countries, I don't know about France, in many countries there are specialized courts. There'll be an intellectual property court, there'll be a railroad court, but we hear everything. And so we do have to do a lot of learning. I had my own patent case where I had to learn some trigonometry, which was very difficult for me. And in patent
They didn't
cases,
teach you that here at Princeton?
I avoided those math courses here at Princeton. But you have to learn the law, the patent law, which is hard enough, and then you have to learn the science, the chemistry, the biology, or the math. But you do it, and it's usually the parties that hire these experts. Sometimes you'll have dueling experts, and you do your best to try and get to the heart of it and to make a decision. But you have to learn it, you have to understand it, and it's up to the lawyers to teach it to you.
And then, in anything involving communication or speech, you run into different cultural norms depending on where you are. So, we probably have the most robust protections of speech in the world. I think our First Amendment probably goes farther to protect free speech than the Constitution of any other country that I am familiar with. I mean, we had the case that was decided by the Supreme Court last year where the people went to military funerals and protested. Very, very, I think most people would agree, extremely offensive speech. It was intended to be offensive. And the court said that it was protected by the First Amendment. So we have that. But then, most countries in Europe have anti-Nazi laws, I mean, for very good reason. I've spent a lot of time in Turkey working with judges there. They're having some real problems with free speech right now, but even before the current problems, culturally it's really inappropriate to insult somebody, and so they have lots of laws that punish people for insulting other people publicly. And so when we get these international cases, you kind of get the overlay of the technology and culture, and you don't want to be, at least, I certainly don't want to be an American saying, well, the way we do things is the right way for the rest of the world, and we're going to. But if you're an American judge sitting in the United States, you got to apply American law. So that's the
Yes.
that's the conundrum. That's the problem.
But I didn't put into question the value of the constitutional principle, but I pointed out that Yahoo had already, at the time, excluded, I read, the sale of cigarettes as well as the sale of live animals, drugs, and anything related to pedophilia from the First Amendment protection, and I believed only that it would not cost them much to remove Nazi memorabilia as well. And it was that. And Yahoo said, no, I am convinced, I am in my right position. I have the right to do what the American First Amendment of the Constitution said. Yes, I said yes. But you and the Constitution are two things.
They're
two
really
different
different,
things.
right?
Yes, and you could do something, and you didn't want. Then I had to decide.
Well, and the irony of it is, that if you go back and read the opinion that I wrote, I mean, Judge Gomez and I agreed on the merits. I mean, I thought Yahoo was very foolish to continue to sell this stuff, and I told them so at the time. But they had a right to, because that's the way our system works, and it was, and I've got Holocaust survivors in my family. It was actually quite painful for me to have to say, actually you do have a right to do this, but it's really dumb and it's really offensive. But that's that's our First Amendment, and it's one of those. Yahoo eventually, I think, got enough bad publicity from the whole thing that they stopped doing it. They took it down and they included the Nazi memorabilia in the banned material, but they did it voluntarily, and that was kind of the principle that they were fighting for.
One of the things that I think is interesting excuse me, about kind of what went on in this case, and then some of the decisions, the Google Books case too, and more recently, though I won't ask you to speak about Aereo since it's before the
I will talk about it.
Okay, great. Then maybe I'll focus on Aereo. I mean, Aereo, one of the interesting things, this is really good here. One of the interesting things about Aereo is so much that the company was playing with the architecture of the system and trying to fit it within some judicial doctrines.
Right.
And I think both Judge Gomez and Judge Fogel, in the Yahoo case, you were grappling with the way Yahoo was presenting the architecture of their systems. And I wonder, how you see this as a judge. How do you perceive your role in addressing these issues, where you each had said earlier in your opening remarks that these are cases where the law is just light years behind where the business world has moved, where the technological world has moved. So what do you do as a judge when your decision is going to have an impact on architecture?
Can I give a little bit of background for those who might not be familiar with Aereo? The Copyright Act says that if you own a copyright, you have the exclusive right to transmit your copyrighted performance, your copyrighted work, to the public. It's called the transmit clause. And so the question is, are you transmitting to the public or is it a private transmission? Aereo captures over-the-air broadcasts of copyrighted programs and then retransmits them over the internet to customers who pay $8.99 a month. So for example, Aereo can capture a broadcast of the Super Bowl, retransmit it to 50,000 paying customers, and it argues that those are private performances. Why? Because Aereo sends the transmission through a tiny antenna. It's the size of a dime, and each person gets his or her own private antenna, and therefore the argument is this is a private transmission. And the trial court agreed, and the majority in the Second Circuit agreed. I dissented, and I said these little itty-bitty antennas are a sham. There's no need for them. They're only doing this to try and circumvent the Copyright Act. That's what I said in my dissent. So that's all. That's all public. The Supreme Court took certiorari, and the case will be argued on April 22nd. It's a significant case. There's a lot of money riding on it. CBS has said, for example, if this stands, we're going to switch completely to cable. No more broadcasting. Why should we create programs and broadcast them if someone can come along and steal our programs? Some of the cable companies are saying, why are we paying retransmission fees? Why are we paying license fees? We could set up our own little itty-bitty antennas and get it for free. So it's about the transmit clause. But my point was, it shouldn't be about the particular technology on how it's done. One should look at the overall purpose and function. And at its essence, this is, in my opinion, a public transmission, because you're sending it to members of the public, strangers who are paying you. That's what the case is about. Now, the majority relied on another technology case called Cablevision, which was decided by the Second Circuit in 2008. And in Cablevision, the Second Circuit reversed me. I was the trial judge in Cablevision. So we're looking for...
Note what happened there. They reversed him as a trial judge, and he's a dissent in the Aereo case.
Yes, and so we are looking for double vindication from the Supreme Court. The Supreme Court hopefully will say that Aereo is wrong and that the Second Circuit was wrong in 2008. I would say this, the United States has put in an amicus brief arguing that the majority in Aereo is wrong. And the United States' word certainly carries a lot of weight.
So is this a decision this sort of decision, let me take it out of just the Aereo context, but is this type of decision one that that you as judges should be making, or is it something that really should be a legislative pronouncement?
Well, both. I mean, I think first, we have to take a crack at it, and we're applying the Copyright Act of 1976. You know, the statute was written 35 years ago, but that's the law today, and so and the internet didn't exist in 1976. So we do the best that we can to apply that statute to these facts. Now, it could be that Congress doesn't like the result, the judicial result, and then Congress can rewrite the law. Yeah. And in fact, another reason why I think I'm right is cable TV was invented when people in some parts of the country were having trouble getting transmissions on their rabbit ears on their TVs. So someone came along and put up a giant antenna at the top of the hill, which would capture the transmissions, and then they transmitted it by cable to private subscribers. The Supreme Court held that those were private transmissions. But Congress rewrote the law. Congress did not like that result. Congress rewrote the law and made it clear that those are public transmissions. And so that's a good example of the courts make a ruling. If Congress doesn't like it, Congress can rewrite the law.
But the problem is, and I do think it's a problem as a judge, they can't make the law fast enough. You know, that the technology changes much faster. And as soon as you make something illegal, then somebody figures out a workaround, and they figure out a way to do it that isn't illegal. So how many people here remember Napster? Okay, so Napster was my kids and I almost went to war over Napster because they wanted to use it, and I said, I'm a federal judge, you can't use Napster. But Napster's kind of quaint now. I mean, there's the ways that you can get music now are much more sophisticated. I mean, I have a thing on my iPad, I'm sure a lot of you do too, called TuneIn Radio, where I can listen to as much music as I want, and I have to listen to a commercial every half hour, but that's not so bad, and so there have been all of these things that have evolved, and you can't legislate fast enough to keep up with them, and I think that's a problem we face all the time. Is it what was intended, and that's what you're talking about with the antenna. I mean, nobody envisioned these millions of little antennas. That's not what they.
Although I will say,
yeah.
Congress, when it redrafted the Copyright Act in 1976, anticipated that there would be changes, and it included in the statute the phrase "by any device or process." Mm-hmm. And so it was anticipating that there would be new technologies that would come along. And then also the market adapts too. Mm-hmm. Sometimes the market takes care of it. Oh, yeah. While we're all waiting for Congress, the market may come up with other plans that are consistent with the court rulings.
It affects other things. Another case that I had that was one of my higher profile ones, it was a libel case against CNN, and there was a statute in California that it's called the breaking news exception, so that if something was said that was untrue but it was said quickly enough that it was breaking news before they really had a chance to go back and edit, they held the media to a lesser standard. In other words, if they figure breaking news is going to have inaccuracies, they can go back and fix them. Well, they defined breaking news as something that had been published within the last 48 hours. Right? Because they were talking about newspapers, right? And then there was no TV when that statute was written, and there was radio and newspapers, and we know every 48 nanoseconds what's going on with the Malaysia airplane, because of CNN. So it's like but that statute is still on the books, or still was at the time of the case, and so I had to decide whether I was going to apply the breaking news exception or not. And it was an unambiguous statute, and the California legislature had never gotten around to changing it. So, I think we have these problems all the time.
Do you have in France?
Yeah.
Do you have the same ability to try to go back and say that the purpose of this law was to accomplish a particular function, and in the face of this new technology, I'm going to follow the purpose rather than what it says explicitly?
Alors en français,
I'll translate in French. Est-ce qu'en France, tu as la possibilité de prendre la philosophie d'origine de la loi pour décider
oui,
la construction du sens
du sens? Oui. Alors, en France, on renvoie souvent au débat parlementaire.
In France, they'll often look to the parliamentary debates leading up to
pour comprendre le sens.
To understand the sense.
Mais les lois sont souvent très très mal construites parce que trop nombreuses.
But the laws are often very poorly drafted.
Yes. Et
trop nombreuses.
Trop nombreuses, il y a trop de lois.
Too many.
Too many.
They have a more frequent legislation than we do typically in the United States.
Et parfois, on traite à la suite d'une loi qui n'a rien à voir avec le sujet, un petit complément qui concerne un autre domaine.
And often, in one law that has absolutely nothing to do with another field, they'll put a little clause that governs the other field.
On appelle cela souvent des lois, disons, de collection, mais
They call them collect laws of collection, so collective laws.
Mais dans ces cas-là, il n'y a pas de débat parlementaire suffisant.
And in those cases, there's almost no parliamentary debate explaining what the provision is or why it was included there.
Donc, le juge a l'obligation en droit civil, hein, en droit civil,
So the judge in civil law has the obligation
oui, de donner un sens à la loi.
to give a sense, to give a meaning to this type of provision.
This is not possible in criminal laws.
They can't in criminal law, though.
No.
They can't interpret in criminal law, but in civil law, they must.
Yes.
They're obligated to.
And then sometimes the judge says something that the Congress did not envisager.
Occasionally,
did not
didn't intend. The judge says
yeah.
something that the Parliament didn't intend.
Yes. So but, les travaux parlementaires sont une source très importante quand ils sont bien faits. Et là, il faut les respecter.
So the parliamentary debates are extremely important in their interpretation and have to be respected. In the U.S., when you're looking at the copyright law or the patent law to try to figure out what to do in a case like an Aereo case or in the patent case, how carefully will you look at congressional materials?
Well, the rule is you start with the language of the statute. If the statute is clear, then theoretically you don't need to go any further.
Yes, yes.
But it's rare that the statute is clear. So then you should definitely look at the legislative history and try to figure out what Congress intended and to fit in with the purpose that Congress intended.
But this is a very serious subject of debate in the U.S. system, because when you start talking about what was intended when, you know, and you have the big debate within the Supreme Court about original intent. You know, we're talking about what was intended in 1789. You know, when one of my favorite lines in the case that Joel mentioned earlier about or actually Denny mentioned it, about the putting the GPS on the car. There's a wonderful line in that. I think it's in Justice Alito's concurring opinion in that case, where he talks about, well, you know, in 1789, the constable would have had to hide under the carriage, you know, to track the suspect, because no one had ever heard of a GPS. So original intent doesn't get you very far, and that's you know, it does. You can go there, but then you have situations where even that doesn't help,
yes,
right? Because they just haven't thought about it.
Yes.
Let me throw out one more, and then we'll start with some questions from the floor. What was the most difficult technology case or issue that you faced, looking at limited to internet-related cases? Who wants to start? Judge Gomez, do you want to start? Qu'est-ce que c'était le cas le plus difficile que
Mais
tu as eu?
disons, rien n'est difficile.
Well, nothing's difficult.
Nothing difficult. You have to understand the case and then to give the best answer on that case, and you must be helped by the lawyers. The lawyer can help you in presenting a very good case, and this is not always the case. Yes. And then after the lawyer, perhaps the experts, as I said, but a case is never, the judge must give an answer on the case. He cannot say, oh, it's too difficult for me, I give the case on my neighbor. No, it's not possible. They are not difficult, but what difficult can be is that people who appreciate the decision of the judges said that the judges didn't understand the problem and the case, and this is. But we do our best, and we have to give an answer in every case.
You know, I could answer that question several different ways. Technically, for instance, I didn't find the technology in the Yahoo case that complicated, in part because Judge Gomez had already explored a lot of it. And so in terms of things that have been technically challenging for me, it's much more how computers are built and how software works. And I mean, that's where I really go kind of right up against the limits of what my brain can digest. But in terms of being a judge and exercising judgment and trying to weigh all of the different factors that go into a case, Yahoo by far, because there were political aspects, there were international law aspects, there were emotional aspects, and technical aspects. And actually, even the legal decision wasn't very hard in the sense that the U.S. Constitution is fairly unambiguous about this. Whether there was jurisdiction or not really was the hot issue in the case from a U.S. law standpoint, and I determined there was, and that decision got upheld by both the Ninth Circuit and the U.S. Supreme Court. But the hard part of the case was, what do I do with the international community? Does that matter? Should a U.S. judge even think about that? And that's still a matter about which very learned judges disagree. So I found that to be very, very hard.
Yeah, difficult can mean a lot of different
Yeah,
things.
yeah.
Difficult can mean complex, lots and lots of paper, and it
Yeah.
just takes a long time to get through it. Difficult can mean an emotionally difficult case. I mean, sentencing someone and deciding whether to send someone to jail, that's emotionally very difficult. Some cases are really close. Some cases are easy. The close ones can be hard. I think in terms of technology, the hardest for me was probably the Cablevision case, where I had to learn about the remote DVR, and and that was 7 years ago when things were still developing. Someone gave me, I think they called it a tutorial, where they just tried to explain all the technology to me, and I had to have a 2-day hearing
To understand the technology.
to understand the technology.
Well, let's start with some questions from the audience. Wow. Yes.
Should the United States set up technical courts? We have maritime courts, do we not?
Actually, we don't have maritime courts as such.
But should we have technical courts?
I think there's a lot of different points of view about that. One thing that is happening now is that Congress authorized a study, a 10-year study, of whether we ought to have specialization in the patent area. So that's a piece of technical courts. And there are 14 district courts around the country out of 94 that have patent pilot programs, and they're experimenting with ways of getting judges on each of those courts to get more expertise in technical matters. It's not the same thing as having technical courts, but it's at least concentrating knowledge in a few judges. As these things tend to go, the original bill had money in it for technical law clerks to help the judges learn the technology. That money was taken out before the bill was passed. So what you have is a bill that says that courts can set up patent pilot programs, and then the Federal Judicial Center, which I'm the director, is supposed to study that and see whether that made any difference, whether the quality of justice was any better, and whether the decisions were technically correct, and whether the litigants felt better about the process. The other issue that comes up with technical matters is the right to a jury trial. So this is the Seventh Amendment, which is almost as sacrosanct as the First Amendment, and there's been no. I don't know that anybody's figured out a fix to that. That if there's money at issue in a patent case or any other kind of high-tech case, the parties have a right to a jury trial. The jurors are not going to be technically skilled, and so you're going to have lay jurors deciding highly technical cases. And I'm sure you've all read about the Apple Samsung case, which is from my home district, and this is about stuff that all of us use, smartphones and tablets and things like that. The technology is actually quite complicated, and it's being decided by jurors who don't know anything about technology. In fact, any jurors who knew anything about technology were kicked off the jury. So my personal opinion, now, although that's a long qualification, my personal opinion is I think we really ought to look at having technical courts. But I think the biggest problem is going to be the right to a jury trial, because if you're going to have a jury, then what's the point of having a technical court unless you have a technical jury? And I think that's getting into some fairly significant structural change.
Yeah, I would just add a couple of things.
Yeah.
Technically, we do have one technical court,
Right.
the Federal Circuit, that hears patent appeals. But so ironically, in the trial court, it's done by generalists, and then the appeals in patent cases go up to the Federal Circuit,
Right.
where they are specialists. In the Southern District of New York, that they have the pilot program. I think it certainly is helpful to have some judges who do this a lot to learn it. But to me, one of the great things about our system is, from my perspective as a judge, is the ability to have lots of different cases. I think you gain some wisdom from learning about lots of different areas of the law and dealing with different people in different areas of the law. One of the difficulties in patent cases is you got to understand it yourself, and then you have to try to explain it to the jury,
Yeah.
so that the jury can understand it. I had one case where I tried to settle it, a patent case, before the trial, the week before trial. I didn't succeed in settling it, but then the parties waived jury. And it made it so much harder for me, because then I couldn't just sit back and let the jury decide it.
Decide the case.
I had to make findings of fact and conclusions
Yeah.
of law, and it was so much more work because it was non-jury. But I agree, I think that in most of these patent trials, it would be pretty questionable to what extent the jury really would understand all of the issues.
And it's actually, what my experience with patent cases before juries is that they actually decide something entirely different than who's technologically correct. It's a morality play. I mean, it's very basic, and it's a great thing about juries, and there's a lot of cases where that's exactly what you need. Is
It
somebody
still
to-
might be justice.
What's right, what's wrong, who are the good guys, who are the bad guys. And I think, in my experience with patent trials, that's how juries approach them. The people put on weeks and weeks of experts and all this kind of stuff, and they say, did the person steal the invention or not? Do I like the defendant or not? And sometimes it's even like, do I like the defendant's lawyer or not? Or the plaintiff's lawyer? And I'm not slamming juries. I'm just saying jurors are people. They're not lawyers. I mean, they're looking at things much more holistically. And I think a lot of cases, if none of those experts ever testified, the jury would still ask the same questions.
Mais dans le système américain,
Yeah.
le juge peut casser une décision du jury.
The question is, in the American system, can a judge void a jury's decision?
Dans les circonstances extraordinaires.
Extraordinary Another question, yes, Senator.
I have a question about jurisdiction. In a case where, there are users all over the country of maybe a particular website or a service that is being, called in question or if a company is being sued, how is that decision made where the case is brought? There are certain geographic concentrations in New York and California, but how do those concentrations happen and what makes those jurisdictional decisions for the case?
Well, I can start. A lot of the cases end up in Northern California or New York because that's where the defendant is located. So that's always a safe place to bring the case. I think they could be brought a lot of other places too, because it's wherever there's a substantial presence. So I don't want to get into too many weeds here, but in the patent world, for a long time, cases were being brought in the Eastern District of Texas, and there aren't any high-tech industries in the Eastern District of Texas. I can assure you of that. But there are patented products or allegedly infringing products that are sold in the Eastern District of Texas, and that's enough to establish a presence. Congress actually has changed that to make it harder to assert jurisdiction that way. But generally, I mean, the reason why the cases tend to get concentrated in certain courts is because that's where the defendants are located.
But I'm going to pick up on it.
Yeah.
One of the interesting
Yeah.
things, I'm going to come back to the Yahoo case and some of the tricky jurisdictional issues that arose in that particular case. There were two forms of jurisdiction. We've spoken mostly about the applicable law portion. In other words, it was the French law was decided by Judge Gomez and the U.S. First Amendment issues that Judge Fogel was asked to decide. But Judge Fogel, you mentioned also the the jurisdiction over just hearing the case in your court?
Well, because the French plaintiffs, the people who brought the case before Judge Gomez, had never been to the United States. It was two groups of students who brought the case. But what the relief that they were seeking was to force Yahoo in Santa Clara, California, to block the content. So they were actually asking Yahoo to do something in the United States, so take a physical act. And there's a line of cases from the Supreme Court, starting with a case called Calder versus Jones, which is it's called the effects test. So if there's a purposeful use of the law, and the intent is that act is to have an effect somewhere else, then the place where the intent is focused can be a place of personal jurisdiction. So in that particular situation, the fact that the student groups wanted Yahoo in Santa Clara to do major surgery to its servers, that's what created the jurisdiction.
I'm going to ask
Yeah.
Judge Gomez,
Yeah.
did you
Yeah.
perceive it the same way that the French parties, the French student group, was seeking activity to take place in California? Est-ce que tu t'es aperçu en fait de la même façon qu'ils demandaient un changement de structure sur les serveurs en Californie?
Je pense qu'il est vrai que les étudiants souhaitaient des initiatives de Yahoo.
It's true that the French students wanted Yahoo to take an initiative, to take
Yes.
action.
Et d'ailleurs, quelques mois après la décision, Yahoo a changé son fusil d'épaule.
And several months after the decision, Yahoo changed its position and,
Yes,
and stopped.
Puisque début janvier 2001, Yahoo a modifié le système. C'est-à-dire qu'elle n'a pas voulu dire qu'elle
In
exécutait.
January 2001, which was 3 months after, a little editorializing, 3 months after his decision, Yahoo changed its system.
Oui, parce qu'elle ne voulait pas dire qu'elle exécutait la décision française.
They didn't want to say that they were applying the French decision, they were complying. They didn't want to say that.
Voilà. Alors, elle a imaginé un nouveau système.
So they came up with they created a new system.
Oui, avant, les enchères étaient gratuites
Before, the auction site was free,
et après, elles étaient payantes.
and afterwards they were charging to list an item for auction.
Voilà. Et comme elles étaient payantes, c'était un cadre commercial.
And when they moved it to being a pay service, it became a commercial activity.
Et on peut contrôler, évidemment, beaucoup mieux les comportements dans un cadre commercial.
And as a result, they could have greater oversight of commercial activity on their website.
Mais dans les faits, Yahoo a exécuté. Mais moi, c'était pas mon problème.
As a matter of fact, the facts then demonstrate that Yahoo complied with the French order.
Yes.
And he said that's not,
It was not my
wasn't my
problem.
problem.
No,
how
no,
they did it was not
Yes.
his problem.
This was all very calculated. They wanted to prove their point under the First Amendment,
Yeah.
which they did, and then they didn't want to have to pay massive fines in France,
Yes.
so they changed their system.
System, yes. And then,
Would your positions be different
Yeah.
if instead of the French students asking Yahoo to make changes on a California server, they were asking Yahoo to make changes on their mirrored site that existed within Europe?
Oh, I wouldn't have had jurisdiction, in my opinion. I mean, I think the only reason I had jurisdiction is that the injunction from Paris required them to take steps in California.
So if the lawyers for the student group in California were better and explained that in fact the site being served in France was not coming from California, but was coming from a mirror that was actually located, I can't recall whether it was the Netherlands or the UK at the time.
Well, those weren't the facts as I understood them. Those
They
weren't
came out about 3 years
Yeah,
after the case
Yeah.
concluded. It came out a couple years
Yeah,
later
yeah.
that they were actually serving from a mirror
No,
site
that's
within Europe.
such a good point, because I remember in the declarations They would say, we actually do want Yahoo to reconfigure its servers in Santa Clara. So that was the linchpin for jurisdiction. If that fact hadn't been there, I would have dismissed the case. Because that was the only way I had jurisdiction.
And that's an interesting comment on sort of the lawyer's understanding of what the technology is and recognizing the significance of it. To be able, what you as the judge heard, that's what you're responding to. If it's not explained, if it were explained differently, then the decision would have been radically different.
Yeah, because it was already a little bit of a reach on jurisdiction, because the students, none of the students had ever been to the United States. They didn't have any presence in the United States. So the only hook was that Yahoo was being asked to do something. And if what they had to do was offshore, that would have been the end of it.
Mais je voulais ajouter que les juges américains, ils avaient déjà fermé des sites qui étaient situés à Antigua.
Judge Gomez wanted also to add that American judges had before the Yahoo decision had ordered the shutdown of foreign websites in Antigua. So in the what you're suggesting is in the United States we had no trouble telling other foreign websites to stop operating.
Yes. Why?
And then there was another question. Yes, in the back.
Metadata collection. We've had dueling judges' opinions. Comments?
On metadata collection, dueling judges' opinions on the collection of metadata.
You mean the NSA? You're talking about what the NSA does?
Yeah.
Anyone want to talk about?
Well, let me first say hello to my friends at the NSA.
Yes, and since Judge Gomez has to go through passport control to leave the country, we may not want.
So, you want to go?
No, I don't. There are different views out there. I don't think it's right to opine on an issue that could come up in front of me, so I will decline to answer. Yeah, we have a New York case that could come up in front of me. So.
Yeah, I think yes.
Do you think the internet and technology issues is increasingly becoming an area that maybe more international law or international governance should be established because you're talking about issues with different jurisdictions?
In Google Books, at the earlier phase, the settlement phase, one of the fun things for me was getting submissions from all around the world, including from France, Germany, publishers in Japan, authors in China, from all over the world. And on a lot of these things, there are international implications. On some things, there are, in life, there are treaties, Hague Convention, there are other things where there are treaties. There are a lot of lawyers out there now who do international antitrust. I don't know that we're ever going to have one international law, but there is a very robust area of practice out there, and it's something to think about. If you comply with the copyright law in one area, in one country, it doesn't mean that you are in another. There was a Supreme Court case a year or two ago about the gray market and selling copyrighted works in another country. So there's an area out there. I don't know that we're ever going to have one statute.
And part of it's just our political system, right? I used to teach ethics classes, and I would always say to lawyers, well, there are things you can do that are legal, but they're dumb. And I think in the business world, if you don't show respect for other people's culture and you're doing international business, you're going to be it's really dumb. It may be legal, but it's not going to help your business. So I think a lot of things happen by agreement. But getting our law to comport to some international standard, that's really hard. And I think just right now, I'm not saying this to editorialize, this is just a fact. There's a treaty that was before the Senate last year that would have required all of the signatures to comply with the Americans with Disabilities Act, basically. It's our law, our standards for disability accommodation, and our Senate wouldn't ratify it because they were afraid we were going to have to give up our sovereignty somehow. So, I think this is really hard to think about how you would have treaties. But I do think, on the good side, that the realities of business are taking care of it, and to a large extent.
Oui,
The French international
Yeah,
perspective?
oui, je pense que pour la défense des droits, en fait, oui.
Ouais.
Eh bien, je crois d'abord il faut commencer par une chose, former nos citoyens, enfin je veux dire nos concitoyens. Allez.
So you're saying, in the context of defense of rights, the first step is you really have to educate the citizenry.
Yes, c'est le point le plus important.
That's the most important
Yes.
starting point.
Et après, former les juges, mais les juges,
And afterwards, train judges.
mais les juges ont une formation permanente tout au long de leur carrière, même aux États-Unis, puisque lui, il assume la formation des juges.
And there needs to be a permanent training function for judges throughout their career.
Voilà.
Au niveau d'une sorte de traité international pour les droits.
Ça, je l'avais dit il y a fort longtemps, seul au moins un environnement international serait déjà utile.
For a long time, he says he's argued for an international environment of rights.
Parce que des lois, je n'y crois pas trop, ça met trop de temps.
Laws, he doesn't really believe in that because it just takes too long for the process to enact.
Je prendrai l'exemple des directives, puisqu'en Europe, on a un ensemble et on est régi par des directives européennes.
In the French context, he's going to take the example of Europe, and Europe has a European directive program, which is at a European level.
Et généralement, il y a de 5 à 10 ans entre le vote de la directive et l'application en droit interne.
And it takes between 5 and 10 years from the time a directive is voted to the time each of the European countries apply it in their internal law.
Really. Et donc, c'est ça qui est trop lent. Parce qu'on on le disait tout à l'heure, la vie sociale, la vie économique ne peut pas fonctionner quand les décisions sont trop lentes.
Social and economic life can't function if these decisions are too far between.
Et donc, il faut accélérer le processus. Et souvent, les seuls qui le font accélérer, ben, c'est comme ça, ce sont les juges.
I said you have to speed up the process, and often the only ones who can really make that process accelerate are the judges.
Yes, this is real. Everywhere, in France, in the USA, everywhere.
Yeah. More questions? I know there's. Yeah.
So you're saying about the time it takes for a law to come, and especially the technology now that's just growing faster. What sorts of things would you imagine that would be good enough? And what sorts of laws would you like to see to let you deal with these sorts of technologies as soon as you
Wow.
I think concept-oriented, and I do think that in the Copyright Act, when Congress put in by any device or process, it was contemplating that it would pick up new technologies, and they said that in the legislative history in the reports. That's a way of dealing with it to some extent. But even then, even concepts change. So
Yeah, I mean, I agree with Judge Chin, but I also think some things we just cannot see around the corner. We just don't know what's coming. And I think about social media. I don't think 20 years ago that any judge I know, including me, saw social media coming. You know, I mean, I think in some sense I had that communication was going to get faster and faster and more integrated, but you know, it's to the point where things can happen as instantly as they do. And then, I mean, the thing that scares me about social media is not the fact that people are constantly using it and, you know, or anything like that. I mean, there's good and bad about that. But the thing that scares me about it is that you don't know who you're talking to. You know, you don't know what you're looking at. You know, and that we haven't I heard a talk last week from a guy who's a cybersecurity specialist, and he's like, basically, we have no idea how to control the internet. You know, that it's just too, it's the Wild West, and you know, we're making small headway, and you have these various kinds of security things you can do, but you really don't know if you're talking. I mean, you could be talking to somebody in you know, Moldova or something, and they claim that, you know, there's somebody who's your neighbor down the street, and I think that's, I don't know that the law really has even begun to come to grips with that, and so that's what worries me about it. But I mean, I agree in general. I think what we can do is have concepts and principles that we as judges can try to apply. I think it's probably the best we can do.
La question c'est, vu ce que tu as dit sur la vitesse, sur le fait que la loi est trop lente pour réagir, si vous avez à dire un certain type de loi, qu'est-ce que vous pensez peuvent quand même vous aider?
C'est-à-dire, quel type de loi? C'est-à-dire que je comprenne la question. Si des lois qui pourraient être d'application immédiate, enfin qui seraient plus rapides dans...
Oui,
oui.
Quel type? Oui.
Oui, ah ben,
Just explaining what the question was.
Oui, oui, mais ce que je crois d'abord, c'est qu'il faut éviter que le Parlement vote trop de lois, parce que ça, il y en a déjà de trop, qu'on reste aux lois qui existent déjà.
The first point is that you really want to avoid that the Parliament votes too many laws. You don't want them getting too active.
Oui, et il serait préférable, me semble-t-il, en fonction des cas qui sont présentés aux tribunaux, de faire évoluer le texte qui existe pour lui donner un meilleur sens et une meilleure application.
So he's saying that what would be helpful is if the Parliament takes the existing decisions, as decisions evolve, to take those decisions and then look to see how they can reform the law to make the law better adapted to c'est la tendance, the trend in the court's decisions.
Oui. Et bien sûr, il y a des domaines que la loi ne peut jamais prévoir, parce que tout avance très vite aussi.
And there are certain areas that the law simply cannot predict in
Voilà.
advance.
Donc il faut une adaptation. Chaque fois que la loi doit être modifiée, eh bien, il est nécessaire que le législateur prenne la situation qui évolue pour adapter sa loi.
So each time the Parliament has to adapt its existing law to what the circumstances, how the circumstances have changed. That sounds like a very American approach.
Yes, why not?
It's a very common law.
Yes, yes.
It's the way the common law works.
Common law functions.
But
Yeah.
I think yes, in France and in Europe we are getting much more.
There was another. I'll take one more in the back.
Yeah.
Yes, so far, talking about the technology itself and understanding the innovations and complexity. What especially interests me is the way in which new technologies are also accompanied by shifting values. For example, fair use. And I follow copyright a little bit, and I've seen there's really been a great change. I saw, for example, a Hungarian film that was really put together entirely out of hundreds of copyrighted films. It was, they said it was, being shown illegally, but I could see a judge saying, well, this as a derivative use, this is a creative work, it does not cause any material harm to the copyright holders. I could see the opposite. So I guess the question is, do you as judges feel that it is your duty or responsibility to reflect changing community standards, or do you think that that is something in a case where there's some gray area, as in fair use, or do you think this is something that should be left to legislatures?
That's a great question. You know, you can't. It gets back to the thing you can't anticipate. I just wrote an article about privacy, so I've been thinking about this a lot. What is a reasonable expectation of privacy? To whom? You know, when you're living out on the frontier someplace, expect that nobody's going to come into your house, nobody's going to listen to your conversations, nobody's going to take pictures of you, without you knowing about it because of your physical isolation. If you're around today, I mean, that goes back to the metadata question, that all of your emails, all of your phone calls, all of your movements, all of that, believe me, it's being monitored. So the question is, well, what is a reasonable expectation of privacy in that context? And as Judge Shin pointed out, I mean, we've got two very capable federal judges who've come down on exactly opposite sides of that question. One said it's okay, metadata gathering is okay, and one said it's not. And I think that reflects what I perceive your question to be, which is what is the role of a judge in terms of expressing the values of the community? Well, what are the values of the community? And this goes back to what I was saying before in my view of this, that maybe somebody my age, in the 60s is saying, well, I think it's outrageous that somebody would listen to my phone calls or track my emails or anything like that. Whereas I think my kids figure, well, everything's on Facebook anyway. Everything is on it's constantly out there to begin with. We know what Kim Kardashian is buying at the grocery store, whether we want to know it or not. And so the sense of privacy is very different depending on where you grew up and how you grew up and who you are. So I think then it gets very tricky for judges to say, or we are the custodians of the values, and I think that is what legislatures are for. So I kind of come down on that side.
Yeah, no, I agree. I don't think it's my
Yeah.
job to say, these are our values and our values have changed. I think that's more for the legislature. I think there's room for saying concepts have changed. The reasonable person concept, we have to apply that all the time in the law. And what I was suggesting when we started was what might have been reasonable 100 years ago might be a little bit different today in that sense. But it's not, I'm not talking about, do we put this value above this value? Things change a lot after 9/11, but I don't really think most of the time that it's that we should be making that value decision and then trying to impose it on others, so.
Oui, un mot. La société évolue, c'est incontestable.
It's incontestable. Society evolves and changes.
Mais les comportements qui évoluent doivent évoluer, je dirais, honnêtement.
But
Les comportements des personnes, par exemple,
individuals' behavior
oui, doivent évoluer honnêtement.
has to evolve honestly.
Et je vais vous donner un exemple. Je ne citerai personne.
As an example, I'm not going to quote
Voilà.
anyone in particular.
Un jour, une personne importante d'ailleurs, qui vivait dans le sud de la France,
One day, a very important person who lives in the south of France
sort de sa maison,
leaves
voilà.
the house.
The
I'll
house.
make it gender neutral,
Voilà.
so I won't express the gender.
Elle va dans son jardin
Goes into the garden,
et elle se dit, tiens, c'est curieux, je n'avais pas vu qu'il y avait un arbre au milieu de mon jardin.
and the person says, "That's strange. I don't remember a tree in the middle of my garden."
Alors elle rentre dans la maison,
Person returns inside her house,
elle appelle ses domestiques
calls her staff. It's a big property,
et ils vont voir.
and they take a look.
Et qu'est-ce qu'ils trouvent? Un tronc d'arbre.
And what do they find? A tree, the trunk of a tree,
Et dans le tronc,
and inside,
un photographe
a photographer,
qui était à quelques mètres d'elle
a couple of feet from her,
et qui prenait des photos.
taking pictures.
Yes. Ça, c'est un vrai problème. Deuxième
It's a real
exemple.
problem.
Deuxième exemple. Avec les appareils photo. On a des appareils avec de véritables bazookas.
With cameras today, you have cameras that have sort of like a bazooka. It's a lens.
Yes. Et des photographes volent des images d'intimité.
And the photographers want images of one's intimate life.
Yes. Mais quand on leur dit c'est inadmissible, vous avez porté atteinte à l'intimité d'une personne,
when one says that they have violated privacy,
ils vous disent, mais non, regardez, la personne était très près de moi, elle a même souri, elle était d'accord.
and their response is no, the person was very close to me, they were smiling and
Yes.
showing that they agreed.
Voilà.
D'accord d'avoir la photo prise.
Voilà.
Agreed to have the photograph taken.
Mais avec l'appareil, il avait pris la photo 100 mètres ou 150 mètres plus loin.
But with that kind of equipment, the picture was actually taken 100 meters away.
Et ça donnait l'impression qu'elle était prise à très près.
And it gives the impression that it was taken right next to the individual.
Voilà, il y a des comportements comme ça qui sont inadmissibles.
And there's certain behaviors like that that are unacceptable.
Voilà, parce que l'argent, parce qu'en fait ils vendent ces photos. J'ai eu une affaire, je termine parce que je sais que je suis trop long, mais j'ai eu une affaire où je voyais venir le photographe vendre ses photos dans un journal en France.
These cases, the photographers sell the pictures. So he saw
Ouais.
this case where the photographer went to sell the photographs
Voilà.
to a
Et des,
newspaper.
des photos comme ça. Alors,
The close images taken from far away.
voilà, et le directeur de la publication, il faisait un tri, il disait « Ah, celle-là elle est bien, celle-là n'est pas bien, celle-là elle est bien », pour faire de l'argent.
So he sees the editor choosing the pictures in order to make money off of them.
Yes. Et c'est ça le problème, c'est que il n'y a pas de censure quand on est honnête.
There's no censure when you're honest.
Et voilà, c'est ça.
And the judge is trying to figure this out where the honesty
Yeah,
is in
yeah,
the system.
yeah.
Well, this has been a terrific and very interesting panel. We're going to have a reception just outside the room, so please join me in thanking our panelists this evening.